Debroy, Dr. Sahoo, Professor Zwieten, ladies and gentlemen, very good morning to all of you. My name is Debanshu. On behalf of my co-founders, Orgo, Vidhi, Alok, and everyone at Vidhi, I welcome you all to our annual Insolvency Conference. We are very grateful to the Insolvency and Bankruptcy Board of India for joining forces with us for organizing this event. We are also grateful to the Faculty of Law and the Commercial Law Center at the University of Oxford for partnering with us for this event. Orgo, Dhwani, Alok and I are all Oxford Law alums, and it's a matter of great pride for us to partner with our alma mater for this event. As all of you know, the IBC has transformed India's insolvency regime. It has inculcated better discipline among borrowers and lenders. It is arguably contributing to better allocation of resources in the economy. As some of you might know, the World Bank's most recent ease of doing business rankings has ranked India at the 52nd position for its insolvency performance. And when we started work on this reform in 2014, India was ranked at the 137th position. So it's a jump of more than 80 positions over the last 5 years. This conference is dedicated to examining this transformative change in a more broader economic and legal context. So we thank you again for joining us this morning for this conference. With this background, I now request Dr. M.S. Sahoo, the Chairperson of the Insolvency and Bankruptcy Board of India, one of the key driving forces for this transformative reform, to make a special address. Thank you.
Respected Chairman of Economic Advisory Council to Prime Minister Dr. Debroy, distinguished Oxford Professor of Law and Finance Dr. Kristin, co-founder of Vidhi Center for Legal Policy, and my friend Debanshu, my colleague whole-time members and other officers of the IBBI, other movers and shakers of the Indian insolvency regime, dear insolvency professionals, registered valuers and other professionals, friends from media, ladies and gentlemen. On behalf of the IBBI, Vidhi Center for Legal Policy and Oxford University, I welcome each one of you to this program on IBC, Impact on Markets and Economy. We are really excited to have you all here. I must thank Vidhi and Oxford University for choosing to partner with IBBI for delivery of this program. I am grateful to Dr. Debroy and Professor Kristin for their presence here. Along with you, I keenly look forward to hearing them. When you talk about the impact on market and economy, in the early morning, I came across this editorial page in Economic Times. The title of the story is Faster, Higher and Stronger. And this is the story by Dr. Arvind Pangaria and Mr. Rajiv Mantri. And this concludes, swift bankruptcy laws does not result in destruction of assets. Instead, it allows a more efficient buyer to acquire them at prices at which they can be deployed profitably. This sums up the entire impact of the IBC on economy and markets. But usually we'll try to look at a more comprehensive assessment from a third-party source, which Mr. Debanshu used, the World Bank Ease of Doing Business, that evaluates the economies in terms of ease of doing business of about 200 countries. India's position this year improved in that assessment from the position of 108 to 52. But more importantly, it used certain data. That is that the recovery rate improved from 26.5% to 71.6%. The time taken for recovery reduced from 4.3 years to 1.6 years. The methodology of World Bank is different. They go by a hypothetical example, they go by a survey approach, but we look at the outcomes slightly differently and we use a slightly different methodology. Let me quote some hard data. Till date, about corporate insolvency resolution process of about 160 corporate debtors have ended up with resolution plans. The creditors of these companies have recovered 44% of their claims, and by claims we mean not only the principal, interest, penal interest, interest on interest, accumulated amount for so many years. Of course, 40% for our skeptics is no good. In fact, they wrote of the Insolvency and Bankruptcy Code when the very first resolution plan in the matter of Synergy Automotives Limited was approved in August 2017, where the creditors had to take a haircut of 94%. That was a company which was in BIFR being seen sick with negative net worth since 2004. It came into the process in 2017 with an accumulated claims of 972 crore including interest, but its liquidation value was rupees 8 crore and the resolution plan gave them 54 crore. They recovered 6% of their claims but 6 times of the liquidation value. If this process were not there, the company would have continued in BIFR for n more years and liquidation value would have depleted further. So one needs to look at the value of the company that the market is willing to pay rather than just the value of the claims in the books of the company or banks. So what is material is what is on the ground and not what is in the air. We expect a few years down the line, as this law enables to start initiate the process in the early days of the default, more companies when they are in reasonably good health come into the process, the outcome would be much better. At least we have a few examples today where the process has been initiated very early days of the default, where the creditors have recovered 100% of their claims. It's important to note that while the creditors have recovered 44% of their claims, they have recovered 210% of the liquidation value. That means if this company were liquidated, the creditors would have got at best 100, but they got 210, meaning that the 110% additional is a bonus on account of IBC. While the World Bank talks about recovery, IBC focuses on the revival. The recovery is only a byproduct. The creditors recovered 210% of the liquidation value after rescue of these companies. Please note that of the 160 companies I just referred to, 1/3 of them were in BIFR or not going concerns. The balance 2/3 companies were in distress, so many deep distress, economic distress, on the way to closure. The code rescued them from their premature death. And this is important because we believe company has an indefinite life by law, but it faces continuous threat to its life from market. Every other company is its predator. A company often takes too much of risk for its survival but gets into problem. It loses business to others on account of competition. Creative destruction often destroys more companies than it creates. So it's not surprising that the average life of S&P 500 companies has reduced from 90 years in 1919 to 18 years in 2019. A company having perpetual succession now lives much shorter than the human. But this IBC now provides a new lifeline to rescue companies from premature death. It does so in two important ways. One is that it empowers the creditors to give or take a haircut of 200% to any or all stakeholders. But more importantly, it allows them to seek the best resolution from the market. All earlier mechanism failed but didn't succeed because it forced the creditors to find a solution only with the existing promoters. They didn't have option to go out, and that made the difference. So beyond the recovery of 1.6 lakh crore, beyond the revival of the firms, the code has ushered in significant behavioral changes. Now the promoters have learned the hard way that if company ever defaults and consequently gets into the corporate insolvency resolution process, in all probability it would move away from their hands. Firstly, because they may be ineligible under the famous section 29A to submit resolution plan, or even if they are eligible, they may not submit the most competitive plan acceptable to committee of creditors. So this credible threat has changed the behavior of the stakeholders, resulting in substantial recoveries for the creditors outside the court. Yesterday there was a press release from Ministry of Corporate Affairs that cites that 9,653 companies, applications were filed, resolution of these many companies. But before they were admitted, they were withdrawn on settlement, and these had an aggregate default of 3.7 lakh crore for the applicants. And this has happened on account of the court. And we know from banks that several accounts are becoming standard accounts reflecting resolution of a default. The debtors are settling default at early sign of distress, and these settlements are happening in the shadow of the code. Therefore, it is important to consider what happens under the code, what happens on account of the code, and what happens in the shadow of the code to have a complete view of the impact of the code on market and economy. And that's why probably Honorable Supreme Court in the Swiss ribbons observed that with the code in place, the defaulter's paradise is lost. And now, no economist talks about twin balance sheet problem that is behind us, which was very acute in 2015. The IBC has created several other markets. It has professionalized the insolvency resolution services, created a market for several professionals, insolvency professional, registered valuers, and improved or increased the market for many other professionals like advocates, accountants, forensic auditors, and so many. Again, an Economic Times report about a week back reported that only the law firms have earned from GST and IBC. I am not vouching for the data, that they have earned 15,000 crore last year. So the market for education and capacity building is also booming. If you go to Amazon, you will find 36 books selling on insolvency and bankruptcy. There are several coaching centers, training places, so many things happening. And IBBI also took advantage of that. It has launched a program called Graduate Insolvency Program, which admits existing professionals with chartered accountants, cost accountants, company secretaries, advocates, BTECs, Masters in Economics, to do a 2-year program, that is 1 year residential at Indian Institute of Corporate Affairs and 1 year internship, on completion of which one becomes eligible to become a registered insolvency professional without requiring any experience. And there is quite a large number of institutions who are queuing up before IBBI for permission to offer this course. This has created also several other markets, market for distressed assets, resolution plans, liquidation assets. The distressed assets are now being bought and sold at in every stage of the life cycle of the distressed asset, and today's Economic Times says that the distressed assets funds are making a beeline to India. This is also a cover page story. But along with this, several other things other market opportunities have also come up. Recently, we had government notified that the normal insolvency resolution and liquidation process applicable to corporate debtors with some modifications shall apply to the resolution and insolvency proceedings of financial service providers, at least in the interim arrangement, and one such financial service provider has started the process. Simultaneously, from 1st of December 2019, government has notified that the commencement of the individual insolvency provisions, starting with the insolvency resolution of personal guarantors to corporate debtors, we are yet to see the market emanating from these additional features which are coming up. By chronological age, IBBI just completed, or insolvency IBC completed 36 months. The toddler years have been very rewarding. It's in the cusp of takeoff, endeavoring to quickly transit to maturity, and it is undergoing prompt course corrections to address deficiencies arising in the implementation of the code in sync with the emerging market realities to further objectives of the code. It has witnessed 3 major legislative interventions in as many years. The 4th one is pending before the Parliament for approval. As the process matures in the days to come, the insolvency regime should improve ease of doing business further. It would improve the economic growth in many ways, and let me tell 2 or 3 ways which directly emanate from the long title of the code. The failure of business dampens entrepreneurship. If it is onerous for an entrepreneur to exit a business, by rescuing viable businesses through corporate insolvency resolution process and closing failing and non-viable enterprises through liquidation, the code releases the entrepreneurs from failure. As more and more potential entrepreneurs recognize this, the code would promote entrepreneurship in the days to come. Second, as many firms default, the availability of funds with the creditors declines, limiting thereby their ability to relent even for genuinely viable projects. On the other hand, low and delayed recovery pushes up the cost of lending, and consequently credit becomes available at a higher cost, at which many projects may become unviable. Through provision for resolution and liquidation, the code strengthens the rights of creditors, reduces incidence of default, and enables creditors to recover funds either through revival of the firm or sale of liquidation assets. It incentivizes the creditors, banks and non-banks, secured and unsecured, financial and operational, to extend credit for projects, and thereby enhances availability of credit in the market. Third, it rescues the failing and viable firms. That essentially means that the failure typically reflects the relative underutilization of resources at the disposal of the firm as compared to other firms in the industry. The code ensures optimum utilization of resources at all times 24/7 by preventing use of resources below the optimum potential, ensuring efficient use of resources within the firm either through a resolution plan or releasing unutilized resources through closure of the firm for more efficient uses. By liberating the entrepreneur from failure, releasing the resources from efficient and defunct firms for continuous recycling, coupled with the improved availability of credit, the code has potential to push up the growth rate by a few percentage points. I am confident that the coming years will be further fulfilling as we together hold the insolvency flag higher. With these words, I welcome all of you once again. Thank each one of you for being here. Wish you a day filled with learning. Thank you.
Quick word about our next speaker. Professor Kristin is the Clifford Chance Associate Professor of Law and Finance at the University of Oxford. She is also the Director of the Commercial Law Centre at Harris Manchester College at Oxford. She specializes in corporate insolvency law. As a matter of fact, she has a doctorate on India's pre-IBC insolvency regime. She has been one of Vidhi's foremost mentors, and we are really, really happy that she is here with us today. Over to you, Professor.
Thank you, Debanshu. Let me start by saying what an honour it is for me to have been invited here to open today's important conference alongside Dr. Sahoo and Dr. Debroy. I'm very happy to be here, and the law faculty at the University of Oxford and the Commercial Law Centre at Harris Manchester College in Oxford are really delighted to be partnering with IBBI and Vidhi for this important event. Some years ago, I began working informally with the Vidhi Centre on aspects of its insolvency law program. And this collaboration allowed me, I think, to observe perhaps a little more closely than most outsiders the remarkable, truly remarkable reform process that culminated in the passage of the Code in 2016. I think the closest English analogue to the Indian reforms is the reform process that happened in the UK on the recommendations, or in response to the recommendations, of the Court Committee in the early 1980s. But the English committee, the Court Committee, laboured for 4 years to produce its recommendations, and the legislative response took a further 4 years to arrive. And moreover, although the English Court Committee did recommend important changes to rules, processes, and institutions, I think it, for the most part, adopted and indeed endorsed the principles that had guided the development of English law over the preceding century, at least in relation to corporate debtors. In contrast, the Bankruptcy Law Reform Committee here in India, working with the support of the Vidhi team and a range of other government officials and experts, successfully made the case, I think, for a change not only in rules, in processes, and in institutions, but also in underlying principles, calling for a radical reorientation that would position creditors at the heart of the governance of corporate insolvency proceedings. That cogent proposals of this kind could have been produced, enacted, and implemented within a little over 2 years is frankly staggering, and I suspect unprecedented on a global scale. As I see it, the defining feature of the committee's approach was its decision to treat creditors as presumptively entitled to determine how the assets of an insolvent corporate debtor should be deployed. As the committee put it, the appropriate disposition of a defaulting firm, quote, is a business decision and only the creditors should make it. And that's from the 2015 report of the Bankruptcy Law Reform Committee. Now, this was a striking departure from the approach that had been taken under SICA, in which, at least until that act was amended by Sarfazi, creditors had very little say over the deployment question. If the BIFR determined that it was not practicable for a company to become net worth positive within a reasonable time on its own, but that it was necessary and expedient in the public interest for rehabilitation measures to be taken, then a lengthy rescue process was put in place under SICA, with huge attendant costs, both direct and indirect. And these costs were, of course, borne by creditors. Each case in which a debtor exited from SICA with a smaller estate than it had on entry was a case conducted at the expense of creditors. More specifically, I think these SICA cases were really, the costs of these cases were really borne by financial creditors, given the judicial practice of permitting non-financial creditors, particularly workers, to escape the application of the moratorium, including in relation to pre-commencement debts. Now, for non-industrial companies, the relevant procedure was, of course, not SICA, but the liquidation procedure under the Companies Acts. But the old liquidation procedure was also, at least in practice, if not by design, similarly debtor-friendly, in that it provided significant opportunities for delay, and creditors had little opportunity to force a quick sale, even in circumstances in which they all thought assets could be put to a better, higher value use elsewhere in the economy. So I think against this historical backdrop, the committee's conclusion that the deployment question, the question, what should be done with this company's assets, given that it cannot pay all its debts in full, was a question best answered by creditors. And the committee's decision to conclude that creditors should answer this question and that insolvency proceedings should best be understood as providing a framework in which creditors could collectively reach an answer to that question was a really radical move by the committee. I think it can fairly be called a paradigm shift, or a call for a paradigm shift, a fundamental change in thinking about corporate insolvency law. Now, the committee's approach was motivated by what we know about the relationship between outcomes in insolvency proceedings, the position ex post, and the cost and availability of credit ex ante. And this, of course, is a relationship that's signalled by the title of today's conference. And the basic idea, which I'm sure you're all familiar with, is this. Those creditors who can adjust the terms of their relationship with the debtor to take into account, firstly, the risk that the debtor will prove unable to pay all debts in full, and secondly, to take into account the way in which the debtor's assets will be treated in such circumstances, and in particular, whether there will be a mechanism for preserving the value of the insolvent debtor's estate. Those creditors who can adjust to these two things will do so. So if creditors anticipate the commencement of insolvency proceedings that are not likely to do a good job of preserving the debtor's estate as it exists at the beginning of the process, that is, if they anticipate a process in which the debtor might leave insolvency proceedings with less assets than they started with at the beginning of the process, then this will be reflected in the cost and availability of credit. In short, poor returns ex post can be expected to shrink the availability of or raise the price of credit ex ante. Now, importantly, and this is what makes the ex ante perspective so valuable and important to understand, while ex post effects will only be experienced by a subset of debtors in the economy, those companies that actually end up in insolvency proceedings, ex ante effects are experienced by all debtors in the economy. So even if you are not a debtor that ends up insolvent, you end up experiencing the effects of adjustment by creditors. And that means that even if you are a low risk borrower, you may end up paying more than you need to borrow for a good project. If you are a younger or otherwise riskier borrower, you may find that external finance is not available at all, even though you have a very good project. Now, the relationship between outcomes in bankruptcy and the cost of adjusting credit suggests that preserving the value of the insolvent debtor estate must be a first order consideration in designing and operationalising insolvency procedures. Now, we might hope for insolvency law to do more than this. We might hope, for example, for insolvency law to improve the lot of those creditors who were not able to adjust the terms of their relationship with the debtor by reference to insolvency risk, non-consensual creditors like tort victims, or simply non-adjusting or weakly adjusting creditors like workers, employees. So we might hope for insolvency law to improve the lot of those creditors relative to the position they would be in if simply left to fend for themselves under non-insolvency or non-bankruptcy law. Now, I think there can be little doubt as to the importance of designing rules to address the position of such vulnerable creditors, although the optimal design of those rules is actually quite tricky, and academics spend a lot of time agonising over this question. But I think if insolvency procedures do not do a good job of preserving the estate of the insolvent debtor as it exists at the beginning of the process, then there is little hope that any other function can be performed. And this is not only because a diminution in assets reduces what is available for redistribution, but also because I think insolvency procedures that do not do a good job of preserving the value of the debtor's estate are procedures that creditors will make every effort to avoid using altogether. And if you have a bankruptcy law that is not used because it's regarded as value destructive, then it won't be able to perform any of these distributional functions we hope that it can perform. And it seems to me that it's not obvious that where creditors make an effort to avoid using bankruptcy laws for this reason, it's not obvious to me that any protections that bankruptcy law provides to vulnerable constituencies will necessarily be mirrored in informal ad hoc responses to insolvency. And this suggests to me that value preservation, preserving the value of the debtor's estate as it exists at the beginning of the insolvency process, has to be a first order goal, whatever your underlying or motivating distributional principle. Now, of course, accepting the importance of value preservation does not necessarily mean that creditors have to be given immediate control over the deployment of the company's assets. You might have a procedure in which managers are given a breathing space to consider the company's options and make proposals to creditors. And under certain conditions, this could be value maximising, particularly if you could access the process early so as to exploit managers' informational advantages about the firm. But such procedures, debtor in possession procedures, require mechanisms to control the risk of expropriation by controllers and mechanisms to check undue optimism on the part of managers. And given that these controls and checks were very starkly absent under the SECA regime, I think it is unsurprising that the Law Reform Committee settled on a manager displacing rather than manager in possession resolution process. The committee recognised that creditors might not always have the best information about the debtor, and that is of course why it recommended the introduction of information utilities as a complement to its insolvency law reforms. But the committee did expect that creditors would have the right incentives as residual claimants to maximise the value of the debtor's estate. And although of course some concerns remain about non-performing asset portfolios in banks, I think the committee was surely right to take as its starting point that creditors could generally be expected to have such an incentive, and certainly to have better incentives, and I think probably better information than the state, which under the old law had such a central role in determining the deployment question. Now, it's one thing to decide in principle that creditors should be presumptively entitled to decide how the insolvent debtor's assets are to be deployed, and quite another thing to operationalise this in the real world. In a trading company, creditors are likely to have much variation between them, both as to their rights against the company and their interests. It may be very difficult for such a group to coordinate so as to reach a conclusion on the question of what should happen to the insolvent company's assets. Secured creditors, who are fully secured, that is, who expect the assets subject to security interests to fully cover their claim, might, for example, favour a quick sale to a third party, even in circumstances where it seems probable that a higher price could be obtained if assets were left in the hands of the debtor, at least in the short term. Unsecured creditors, on the other hand, might be expected to be opposed to such a value-destructive course of action. Now, the problem in a case like this is, of course, not that creditors disagree on how to preserve the value of the debtor's estate, but that some of them are not adequately incentivised to preserve that value. But I think even where creditors are all incentivised to preserve the value of the debtor's estate, I think they can in good faith disagree on how this can best be achieved. So in this part of my address, I wish to contrast the approach that English law takes to resolving this problem, how to enable creditors to reach agreement, with the approach that I understand to be taken under the Indian Code. So what's the English approach to solving this problem of enabling creditors to reach agreement on what should be done with the debtor's assets? Well, English law provides a procedure called administration, in which all creditors, including secured creditors, are stayed from enforcing their claims against the assets while the deployment question is decided. But rather than put the deployment question directly to those best incentivised to maximise value, the general body of unsecured creditors, English law recruits a third party, the insolvency professional, the administrator, who's a regulated insolvency practitioner, and asks effectively the administrator to decide this question on behalf of the general body of unsecured creditors. Now, reading the statute on its own, one would be forgiven for thinking that creditors must in every case decide the deployment question themselves. For the process set out in the statute book under English law is one in which the administrator formulates proposals which have to be approved by a majority in value of voting unsecured creditors before they can be implemented. So if you were to read the statute book, you would think the administrator can't really do anything without first obtaining the approval of unsecured creditors. But English courts have always interpreted these provisions to permit administrators to exercise their powers before asking unsecured creditors for approval, where they think it will serve the purpose of the administration for the administrator to act in this way. And because these powers include a power to sell company assets, subject only to a rule that the consent of a fixed security interest holder has to be obtained in advance, Because administrators have a power to sell company assets, the result is that the administrator can move to sell the whole or any part of the business without obtaining the prior approval of unsecured creditors. Moreover, if the administrator thinks that such a sale would achieve a better result for unsecured creditors than rescuing the company itself, but that value will be lost by trading the company in a public insolvency process for a long period of time, the administrator can decide to negotiate a sale of the business in advance of the commencement of the proceedings that is designed to take effect immediately on commencement. The result in such a pre-packaged sale under English law is that the business is sold at the same time, or perhaps even before, unsecured creditors learn that the company has gone into an insolvency procedure. Now, when there is a ready market for the purchase of a business on a going concern basis, there is good reason to think that creditors would prefer for it to be sold to a new owner than to remain in the hands of the debtor, because leaving the business in the hands of the debtor requires you to deal with the company's debts. It requires those debts to be reorganised, renegotiated, and this requires bargaining with creditors, and that bargaining is costly. It's hard to achieve. In a sale, assuming there is power to sell the assets free and clear of security interests, assets can be sold and liabilities left behind, and no bargaining with or between creditors is required to determine how the purchase price is to be distributed. If the consideration is paid in cash, then you can simply distribute the proceeds in accordance with the priority rules provided in liquidation. There's also good reason to think that creditors would prefer a quick sale to a more drawn-out one, because going concern value can rapidly dissipate once a company is in public insolvency proceedings. And all of this suggests that the ability to sell a business quickly, indeed even on a pre-packaged basis under English law, may enable value to be preserved, provided, of course, that the administrator negotiates a proper price in that sale, and that the administrator's own costs can be properly controlled. And these two provisos, proper price and limits on the administrator's own costs, have been taken very seriously by Parliament, by English courts, and by the regulators of the insolvency profession in the UK. Administrators are subject to a range of duties designed to ensure they act in the interests of unsecured creditors, not just the interests of those fully secured creditors who might favour a quick, not necessarily value-preserving sale. And in the case of a pre-packaged sale, these duties are buttressed by detailed disclosure obligations that require the administrator to fully justify why they chose to sell the business on a pre-packaged basis and to explain their marketing strategy. Remuneration has also become increasingly regulated in the UK. Now for the Indian approach under the code, and I know that you are all much more expert in the code than I, so I hope you'll forgive any errors in this part of my analysis, and I look forward to discussing with you this as the day proceeds. So like English law, the Indian code provides for the commencement of a procedure during which all creditors, including secured creditors, are stayed from enforcing, while the deployment question, what is to be done with the assets given the company's inability to pay its debts in full, is decided. And as under English law, managers are displaced from exercising their management powers, and an independent, regulated third party, the resolution professional, is appointed to manage the affairs of the company. But whereas under English law, the administrator is essentially asked to determine the deployment question on behalf of creditors, the Indian Code, I think, asks creditors, or more specifically financial creditors, sitting as the committee of creditors, to determine this question for themselves. The plan for resolution is not developed by the resolution professional, but by other interested parties, the resolution applicants, subject, of course, to the rules and the regulations on the content of plans. And the resolution professional's role, I think, is really restricted to examining any such plan for conformity with the code's rules on the treatment of expenses, the treatment of non-financial operational creditors, and the treatment of dissenting financial creditors, and of course adherence with any other rule of Indian law. And during the process of soliciting and examining plans, the resolution professional cannot exercise their most significant powers without the prior consent of the committee. and this includes a sale. The regulations, of course, give the resolution professional power to sell unencumbered assets where such a sale is likely to be value maximising. But crucially, this power cannot be exercised without the prior approval of the committee. Now, the committee would have had very good reason to be worried about recommending that resolution professionals be entrusted with the degree of power that the English administrator has come to enjoy under English law. Because, of course, at the time the committee was making its recommendations, there was not yet an established market for insolvency professionals in India. Seeker, being a debtor in possession procedure, did not require the appointment of an insolvency professional. The liquidation process under the Companies Acts, of course, did, but in compulsory liquidation, the rule had been from 1956 on that only the official liquidator, those attached to the High Courts on the appointment of the central government, could be appointed to act as a company liquidator. I think it would have been a very significant step for the committee to both recommend opening up the market for insolvency services to the private sector and recommend entrusting the deployment decision entirely to such professionals. The risk that this would have simply become a new channel for value destruction would, I think, have been an obvious one. So, to my reading at least, the committee settled on a hybrid approach. It would become possible to appoint liquidators from the private sector, even in an NCLT ordered winding up. And like the official liquidator under the Companies Acts, liquidators under the code would have power to realise unsecured assets with a view to making a distribution without prior creditor approval. But resolution, rather than liquidation, would be the default procedure. The first phase would always be resolution. And in this phase, the crucial question of what should be done with the company's assets would be decided not by the resolution professional, but by financial creditors themselves. Now, though perfectly explicable, I think, given the historical context, the model of direct creditor decision-making used in the resolution chapters of the Code seems to me to be not entirely free from difficulty. Firstly, I think such a model may make it a little bit more difficult and therefore costlier for a third party to acquire the business. Now, the Code, of course, does not prescribe the content of a resolution plan, and as is clear from the regulations, it's perfectly possible for a resolution plan to provide for a sale to a third party. The difficulty, I think, is that creditors have to bargain to reach this conclusion, and that bargain will be costly to conduct and to supervise. Creditors might have an incentive to behave strategically, and in particular to withhold their consent with a view to obtaining more than they would have if the resolution professional had simply had power to decide on their behalf that returns would be maximised by a sale, authorise the sale and distribute the proceeds in accordance with the priority rules in section 53 of the Code. To put this point another way, I think by requiring creditors to decide the deployment question directly, I think the Code effectively requires, or at least invites, creditors to bargain not just over deployment, what should happen to the assets, but also distribution. What should each creditor's entitlement to the proceeds of the acquisition be? And I think the result is that there'll be no particular reason under the Code to favour structuring an acquisition by a third party as a sale of assets rather than as a sale of shares in the company. Because the key advantage of an asset sale, in theory, as I've already said, is that it avoids bargaining over entitlements. And that, I think, can't be avoided under the Code. Now, if it were possible for assets to be sold without bargaining over distributional entitlements, this should, assuming the costs of that process can be properly controlled, be a cheaper process to administer. And if I could just give a practical example, we could think about the SR Steel case, which of course has been a very high-profile case covered in the UK as well as extensively in India. If in SR Steel, the resolution professional had been empowered to sell the business to Mittal by transferring assets and leaving liabilities behind, then I don't think there would have been any need for the NCLT, the NCLAT, and the Supreme Court to consider the distributional entitlement of Standard Chartered Bank. The entitlement would have been that provided for in liquidation under Section 53. Removing the need to bargain over such an entitlement and any associated litigation risk would reduce the direct costs of the process, I think, improving returns to creditors ex post, with associated positive implications on the cost and availability of credit ex ante. And if I may make just one final point about this, note that allowing for the possibility of a pre-packaged resolution plan would not nearly offer the same degree of benefit if the rest of the code would stay the same. Yes, under a pre-packaged resolution, the time in resolution would be shorter, reducing perhaps some of the indirect costs of being in a public insolvency process, but you'd still have to bargain over entitlements, and that costly bargaining would still have to occur. It would just happen before the process rather than after the process commences. Now, there will be cases in which value will be most likely to be maximised by keeping the assets with the debtor itself, even allowing for the costs of this renegotiation, the costs of the bargain. And I think this is the outcome that the resolution provisions of the code are really directed towards facilitating, enabling the company itself to stay alive. But here too, I confess to having some doubt as to whether, in present form, they are entirely optimally designed to facilitate the striking of this bargain. Now, in common with English, US law, and the law of many other jurisdictions, the code provides a stay so that creditors cannot grab, destroying value, nor can they leverage the threat of the grab to try to get more than others. And the code also, in common with other jurisdictions, provides rules by which a minority of creditors can be bound to a plan approved by the requisite majority. But I think two features of the code are a little more unusual. The first is that the only parties to the plan negotiation are financial creditors, although operational creditors are bound in the same way as dissenting financial creditors once the plan is sanctioned by the adjudicating authority, the NCLT. Now, of course, there's a very important rule that operational creditors receive not less in the bargain than they would have received in a liquidation, or, having regard to the recent amendments, not less than they would have if the priority rules that applied in liquidation were applied in the resolution, whichever is the greater. And I think this rule, in its amended form after August of this year, goes a considerable way towards mitigating the risk of oppression that would otherwise arise by deciding to give decision-making power to financial creditors alone. So I think the position of operational creditors has been much improved by that recent amendment. Now, in practice, of course, some operational creditors will likely do better than dissenting financial creditors, because there will be some relationships with operational creditors that are so important to the debtor, so valuable to the debtor, that it's worth paying them in full. So sometimes an operational creditor will get their pre-commencement claims paid in full with a view to securing their ongoing relationship with the debtor. But I don't think this will be true of non-consensual operating creditors, like, for example, tort victims. They won't be able to secure that kind of ransom payment. And it does seem to me that the position of non-trade creditor and non-employee creditors who are not financial creditors, so the other categories of operational creditor, it seems to me that these creditors occupy a peculiarly vulnerable position under the code because of where they appear in the ranking under Section 53. If I understand Section 53 correctly, they rank below financial creditors. And I don't think if you're a non-consensual operational creditor, you're going to have much ability to negotiate for a better position in a distribution. And so that may be something worth rethinking at some point in any revised version of Section 53. The other unusual feature of the code is that it brings all financial creditors together as a single class or a single decision-making body, whether they are secured or unsecured. Now, of course, the code, as amended following the developments in the SR Steel case, of course, the code now makes clear that the bargain struck in the plan can be one which differentiates between secured and unsecured creditors, and that's plainly right, eminently sensible. But the code doesn't require this. There is no absolute priority rule in the code that secured creditors have to be paid in full before junior creditors can recover, nor is there even, I don't think, a relative priority rule of the kind we now see in EU law that requires at least for senior creditors to recover proportionately more than the classes below, although in practice I'm sure that they do so recover this. Now, it's true that the code requires dissenters to get at least what they would have recovered in a liquidation under Section 53, but I think this arguably sets the bar a little low, because the point of resolution is or should be to preserve more value than should be able to be preserved in a liquidation. And in any case, I think a rule of this kind, a rule which says you must get at least what you get in liquidation, is much harder to apply than an absolute priority rule, because it requires you to conduct a counterfactual exercise to imagine what the position would be were the company to go into liquidation. So it's a much costlier rule to apply than a rule which simply says secured creditors rank 1 and that priority should be respected in resolution as it is in liquidation. So I think the result is that under the code, wealth transfers from secureds to unsecureds are at least a non-theoretical possibility. They're a real possibility that the adjudicating authority must be alert to. And although I think the Supreme Court in SR Steel was right to say that ultimately the plan is a matter of the commercial judgment of the creditors and that courts should not substitute their own judgment for the commercial judgment of creditors, I think any law that enables a minority to be bound by a majority has to provide safeguards against oppression. And the greater the risk of oppression, the more likely you have to use the safeguards with associated costs. Additionally, and more fundamentally, it seems to me, following reasoning in a recent academic paper by some US academics, I think the absence of something like an absolute priority rule will likely make it a little bit harder than it would otherwise be to negotiate a consensual reorganisation. If we think about reorganisation laws as providing rules for the parties to bargain in the shadow of, I think the code's open-ended nature is not as likely to facilitate cheap bargaining in the same way that a more absolute priority rule might, because unsecured creditors simply do not know the outer bounds of what they might be able to bargain for under the code. So to conclude, next steps. I think there is so much to celebrate in the code. I think the committee's decision to put creditors at the heart of the code was a hugely significant step in the development of Indian law. A development that I think is likely to yield significant benefits for debtors ex ante, and I agree with Dr. Sahoo that the preliminary evidence is consistent with this, that there's much to celebrate. Yet, as with any law, there remains scope for further refinement. If the first order goal is to preserve the value of the debtor's estate, and I have suggested that it ought to be, then there may be a case at some point for moving from direct creditor control through the Committee of Creditors to indirect control, i.e. more power to the insolvency professional, with a view to enabling businesses to be readily sold to third parties at cheaper cost, of course once the insolvency profession has further matured into its new roles. In cases where value would be preserved by leaving the business with the debtor, I think the process of renegotiating entitlements might, paradoxically, be eased by moving from a single class voting structure to a model in which creditors are separated into classes that better reflect their differing rights against the debtor. And that would be an approach taken in many jurisdictions to this question of voting where you're not all similarly situated. The best reorganisation law, as I've said, is one that hardly has to be used at all, for its effects are so predictable that parties can easily bargain in its shadow. If these reforms are thought to be sensible ones, then I think there is every reason to be confident that they can be achieved. To me, one of the most remarkable features of the post-2016 period has been how significant and sensible changes to the code have been able to be made with considerable speed. Consider, for example, how the Section 29 restrictions were rapidly relaxed in relation to small and micro businesses, a very helpful and sensible relaxation in my view. Serious efforts have been made by IBBI and others to collect and report data on the operation of the code, resulting in data sets that are already far richer than anything that we researchers could access in relation to the old law. Every effort, I think, is being made to produce an insolvency law that preserves the value of the debtor's estate for the benefit of its creditors. So I think there is every reason to be optimistic. Thank you very much.
Our next speaker, Dr. Bibek Debroy, is one of India's most prominent economists. He is currently the chairman of the Economic Advisory Council to the Prime Minister. He has also served as a member of the Niti Aayog. Dr. Debroy has taught at several prestigious institutions, including the Presidency College in Calcutta, the Gokhale Institute of Politics and Economics in Pune, and the Indian Institute of Foreign Trade in New Delhi. Between 1993 and 1998, he was also the director of a Ministry of Finance UNDP project on legal reforms. He's also a prolific author and has authored numerous books in the fields of economics, polity, and Indology. Over to you, sir, for your inaugural address. Thank you so much.
Dr. Sahoo, Dr. Van Zwieten, Mr. Mukherjee, ladies and gentlemen, let me congratulate Dr. Sahoo personally and IBBI and Vidhi and the Oxford Centre for having invited me here. I'm particularly thankful that it's the fag end of the inaugural session, because after that introduction by Dr. Sahoo and after that comprehensive presentation by Kristin, there's actually nothing for me to say but to say thank you and sit down. I congratulate all the co-hosts for organizing this. And I'm delighted that such a conference is being hosted, and this is just the inaugural session. There will be many other sessions. I've seen the program in the course of the day. Let me step back a little bit from what has already been said. Mention has already been made of the World Bank's ease of doing business rankings. And indeed, Dr. Sahoo is absolutely right that the World Bank's doing business rankings is not really the primary intention for doing what India has done in this area or in other areas. A better rank in the World Bank's doing business rankings is at best a byproduct. Having said this, I don't know how many people in this room are aware. This room consists of people who are generally aware, but I don't know how many of you are aware that the World Bank's ease of doing business indicators are based on surveys in just 2 cities. And the sample sizes on those questionnaires, sample sizes mind you, for India are around 30. And for some other countries, which I shan't name, the sample size is 2 or 3. But nonetheless, it's the World Bank, so it's the World Bank, it does various things. Most people here are aware that the World Bank's ease of doing business rankings are based on 11 heads, 10 of which are actually included in the overall ranking, 1 is not, labor is not. And there is one which is the enforcement of a contract. That has not just the subjective responses to questionnaires, it also has some objective data. In that particular head, there is a 25% weightage attached to a cross-country index of legal infrastructure that the World Bank has. I have not been able to find any information, despite this world of transparency, about how that index of legal infrastructure is constructed. So I would urge Vidhi, which everyone present here knows does phenomenal work in the area of broadly law, to probe how this legal infrastructure index is constructed. As I said, it's cross-country. Dr. Sahoo began with a quote from an article in Economic Times, which effectively invokes the motto of the Olympics, Citius, Altius, Fortius. India's track record in the Olympics has not always been very good. It has incrementally improved, but at one point it was essentially hockey. It has improved, but most of the medals in the Olympics are in track and field and swimming. So until India does better in track and field and swimming, the Olympics record will not improve. Now notice about track and field and swimming, those are individual sports. So the country may provide a conducive environment for competition, but it is individuals which compete. It is individual companies which compete. Some of us, a very few I think, are economists in this room. And economists will talk about competition. Competition definitionally means free entry and free exit. You cannot have competition with free entry with no exit. In India, we are very unfamiliar with the phenomenon of exit. We have always been. When the 1991 reforms were introduced, in the initial years, it was always about liberalizing entry. Very little was said about exit. Today in the newspapers and elsewhere, there is a debate or a discussion on what needs to be done to step up the growth trajectory. And there are some people who talk about structural reforms. If you go down that list of structural reforms, depending on who is writing, you will find a reference to privatization of central public sector enterprises, which is fair enough. But there's a youngish generation here. So I do not know how many members of this youngest generation are aware that half the Sikh public sector enterprises were originally Sikh private sector enterprises, which were not allowed to exit but were nationalized. Through a series of statutes, particularly concentrated in the 60s and the 70s. In that list of reforms, structural reforms, people will mention labor reforms and will particularly focus on Chapter 5B of the Industrial Disputes Act. Chapter 5B of the Industrial Disputes Act is invariably labeled as an exit policy for labor. It's not. It's an exit policy also for companies. The phenomenon of exit, therefore, has been unfamiliar. And however you define reforms, whichever aspect of reforms you talk about, it's about competition. And we need exit. We need exit of companies. We need reforms on efficient capital markets so that that exit happens. This exit is not only about the corporate sector. And I'm glad Kristin mentioned the unincorporated enterprises also. Before IBBI came into being, the exit provisions, so-called exit provisions for unincorporated enterprise was a piece of legislation that went back to 1926. This is the first time since IBBI that we have actually witnessed exit, and we've witnessed exit of promoters. 15 years ago, if you had asked anyone, are these promoters likely to ever exit? The answer would have been a flat no. Because we all know that there was a kind of nexus, a way of doing business, which ensured that errant promoters did not exist. But before the but, the code, like many other pieces of legislation, is work in progress. If it is work in progress, it is welcome that the piece of legislation should be tweaked as one goes along to improve it, to make it better, because particularly in an area where you don't really know what that template is, this tweaking of the legislation, and both Kristin and Dr. Sahoo mentioned the recent amendment which is pending, per se these amendments are desirable. Having said that, firstly, the subtitle says impact on markets and the economy. And Dr. Sahoo drew an analogy with GST. In the case of GST, which is also work in progress, when GST was introduced, there were people who said that GST would lead to incremental GDP growth of between 1.5% to 2%. Disregarding the fact that estimate was done by NCER for the 9th Finance Commission for a terminal ideal GST, whereas GST being work in progress, which will take maybe 20 years, it is not as if you are going to get a 1.5% to 2% GDP growth overnight. There are pains. Dr. Sahoo did not give a precise figure, but he said a few percentage points in GDP growth, obviously eventually. But in the process, there will be costs. There will be costs because those efficiency gains, and those efficiency gains are indisputable, those efficiency gains happen in the longer run. In the short run, there will be costs. In the short run, not just for the code, but generally, as we switch from an old way of doing business, which we were familiar with, which was inefficient, to a new way of doing business, which is likely to be more efficient, but towards which we haven't yet moved, there will be short-term costs, including growth costs. So let's accept that. Secondly, here, and including in the sessions, we are talking about the code. But the code involves a certain judicial process. And I ask you to cast your minds back to the amendments that were done to the Civil Procedure Code in 2001 and 2002, when it was argued, because it was felt that the amended Civil Procedure Code would reduce the duration of an average civil dispute to 1.5 years. Has that happened? It has not happened. Because there is a judicial process, and there is a judicial process which can also be circumvented. Many years ago, when I interrupted the introduction, the last sentence said I was involved with a law reforms project many years ago. When I was involved with a law reforms project many years ago, I was introduced to a lawyer and asked what is his expertise. And I was told his expertise was a certain section in the Civil Procedure Code which enabled him to ensure adjournments and delays. So therefore, it's all very well to talk about the code, but we should also talk about NCLT and the processes in LCLT and the processes in LCLT which can be used to delay the process. The third point I want to make is, and this is I'm not starting a debate with you, but I'm just pointing out that anyone who's worked in India would say that one should be legitimately skeptical about so-called independent professionals. Independent professionals in other areas have not exactly covered themselves with glory. So there is a broader issue of corporate governance or corporate misgovernance, and because we are still testing the waters, we are still in very, very preliminary stages. But finally, let me again congratulate all the three partners for having organized it, and I would strongly urge some of you, because it's difficult for Dr. Sahoo to do that, some of you to look at also the functioning of NCLT. Thank you very much.
Before we close, may I request Dr. Sahoo to please hand over two small mementos to Professor Van Zwieten and Dr. Debroy, please. Thank you. Thank you so much, ladies and gentlemen. We break for tea now and we reconvene at 11:50 for the next session. Thank you so much.